Welcome to International Trade Minute Quickfire Trade News, the essential podcast for today's trade professionals, presented to you by Rydell Law Firm. If you're a seasoned practitioner, this is where you'll find your weekly distilled briefing on the pulse of international commerce and regulation. We bring you the latest legal and trade news, distilled into straightforward, bite-sized updates for busy trade professionals. Sponsored by Rydell Law Firm, this podcast is crafted by expert trade attorneys to keep you ahead of the curve with concise, actionable insights. Perfect for your morning commute or coffee break. Stay informed without the fluff. Subscribe now on Apple Podcasts and Spotify, and join our professional community on LinkedIn. Today, we are exploring the main topic, latest enforcement and regulatory updates in international trade, including subtopics like CFIUS penalties, CBP de minimis enforcement, a recent court ruling on Type 86 suspensions, and new proposed rules from BIS and DDTC. Let's get started. In 2023, the Committee on Foreign Investment in the U.S., CFIUS, escalated its enforcement activities, setting a new record by fining 4 parties for breaching mitigation agreements and probing numerous others for failing to meet mandatory filing requirements. Detailed in an annual report, these actions underscore CFIUS's intensified focus on compliance and enforcement. Paul Rosen, the Treasury Department's Assistant Secretary of Investment Security, characterized 2023 as a notably busy year. Reflecting on CFIUS's priorities, he noted that last year was pivotal in enhancing diligence and due process in their reviews and investigations. It's worth emphasizing that CFIUS had only publicly announced 2 penalties in its nearly 50-year history prior to last year's record-setting 4 penalties. However, Rosen made it clear that 2023 marked a turning point with stricter enforcement measures and a more robust toolkit for scrutinizing transactions. CFIUS's annual report revealed penalties for breaches of material provisions in mitigation agreements addressing national security risks from foreign investments. Upon identifying breaches, the committee's monitoring agencies acted quickly to pursue remediation and determine civil penalties. In April 2023, CFIUS proposed higher maximum penalties to enhance compliance. The committee also investigated non-compliance with mandatory filing requirements, resulting in several formal determinations. Notably, CFIUS received its first voluntary self-disclosure for a potential non-filing, indicating growing caution among foreign investors. Although no fines were imposed, this led the Treasury to issue new guidance on defining a transaction's completion date as when the foreign party acquires any equity interest in the U.S. business. Despite the spike in enforcement activities, the report noted a decline in both the number of notices and investigations from 2022 to 2023. Notices dropped from 286 in 2022 to 233 in 2023, while investigations fell from 163 to 128. This reduction might initially seem contradictory, but Rosen attributed it to a more efficient process that streamlined reviews and reduced the withdraw and refile rate from 23% in 2022 to 18% in 2023. He emphasized that the evolving national security landscape continues to pose complex challenges, requiring CFIUS to handle a significant caseload efficiently. In terms of transactional data, of the 233 notices received, 57 were withdrawn, with parties opting to file new notices in 43 of those instances. Notably, in cases where CFIUS identified national security concerns that couldn't be resolved, some transactions were abandoned. Also, in 2023, the committee identified thousands of potential non-notified transactions, inquiring into about 60 and formally requesting filings for 13 cases, consistent with 2022 figures. Treasury's increased vigilance underscores the need for meticulous compliance. Key takeaways for practitioners include rigorous adherence to CFIUS mandates and understanding the new guidance on transaction completion dates to avoid penalties. CFIUS averaged just over 7 business days for draft notice comments and around 46 days to close reviews, consistent with previous years. In 2023, about 21% of distinct notices required mitigation measures, including restrictions on intellectual property transfer, handling sensitive information, technological safeguards, and personnel restrictions, all to mitigate national security risks. Moreover, The report starkly reminded us of the ongoing threat posed by foreign governments, particularly through cyber attacks targeting U.S. technologies, with actors from countries like China, Russia, Iran, and North Korea persistently seeking proprietary information. As CFIUS continues its trajectory towards heightened enforcement and efficiency, trade practitioners should remain vigilant, aligning their practices with the evolving landscape to navigate foreign investment transactions successfully. This concludes our detailed analysis of CFIUS's record-setting enforcement activities last year. For practitioners, it's clear the road ahead demands rigorous compliance and proactive measures to align with CFIUS's stringent expectations. Remember, staying informed is your first line of defense against unexpected setbacks in this dynamic trade environment. Moving on to our next article, CBP plans to enforce the $800 daily aggregated limit for de minimis shipments on the ACE platform, starting September 29th. This significant change is intended to automate the enforcement of Section 321 requirements, but it has raised several concerns within the trade community. Practitioners are grappling with potential disruptions, especially those related to the calculation of the de minimis threshold and how enforcement measures will be applied. A key issue here is the accuracy of shipment values and the timing of their arrival. Customs brokers have highlighted the difficulty in estimating whether a shipment exceeds the $800 threshold, particularly when the estimated date of arrival might differ from the actual arrival. This discrepancy is especially problematic for ocean and air shipments. Questions remain on how CBP will validate the de minimis threshold, whether they'll base it on the estimated or actual arrival date. Consultant Cindy Allen notes that the enforcement could be particularly disruptive at northern and southern borders, where truck carriers frequently request de minimis release for their manifests. If a shipment at the border is found to exceed the $800 threshold, it is presently unclear what actions CBP will take. Will the whole shipment be rejected, returned, or will specific penalties be imposed? Furthermore, Amy Magnus from A. Derringer emphasizes the practical challenges of last-minute loading. Often, cargo details are finalized only as containers or trucks are being loaded, making it challenging to preemptively ensure compliance with the $800 limit. This scenario creates anxiety as stakeholders wait to see if CBP will reject their shipments after the data is transmitted. If a shipment is rejected for exceeding the threshold, there's uncertainty about the fate of the cargo. Will it be turned back, held in bond, or require a new entry? A potential solution to ease the transition into this new enforcement phase is an informed compliance period. During such a period, CBP would allow shipments to proceed while informing stakeholders if their consignments exceed the $800 limit. This approach would help importers, brokers, and carriers adjust their processes without facing immediate penalties. Another pressing concern is the visibility of shipment data. Currently, only CBP has comprehensive insight into how many shipments breach the $800 limit. Giving stakeholders access to this data could help them better manage and anticipate compliance issues, reducing the surprise of a potential rejection. Nevertheless, despite the growing concerns, the overarching sentiment is that the enforcement of the threshold is a lawful necessity. While the de minimis threshold has been in place for over a century, CBP's new tools for enforcement are a first, and there's a general consensus that compliance is essential. As Magnus aptly summarized, while the law must be upheld, it's critical to see how these enforcement efforts will play out in real-world conditions. Up next, the Court of International Trade has denied Seco Customs Brokerage's bid for a temporary restraining order and preliminary injunction against its suspension from the Entry Type 86 and CT-PAT programs. The denial stems from a ruling that Seco already received all the relief it sought when conditionally reinstated into these programs and given reasons for the original suspension. Judge Claire Kelly stated that Seco's evidence of harm was weak, noting that speculative business and reputational harms do not warrant an injunction. Seco had claimed financial loss and business damage from the suspension, but the court determined that these were typical costs faced by businesses under regulatory scrutiny, not irreparable harms. CBP had suspended Seco and several other brokers in May from the Entry Type 86 pilot program, citing significant non-compliant filings. Seco's subsequent lawsuit sought multiple forms of relief, including protection from having to take remedial actions and a clearer timeline for addressing violations. However, the court found these requests moot after CBP conditionally reinstated SECO and provided detailed reasons for the suspension. In seeking further relief, SECO argued that the suspension caused enduring financial and reputational harm and the loss of clients. However, the judge concluded that SECO's claims of economic and reputational damage were speculative, lacking clear evidence of when and why client relationships were severed or how full reinstatement would remedy their losses. The Court of International Trade emphasized that injunctive relief demands clear evidence of impending harm, which it found lacking in SECO's case, reaffirming that compliance with regulatory standards is a necessary condition for participation in the Entry Type 86 and CTPAT programs. This ruling holds that speculative economic loss or business impacts do not justify the extraordinary remedy of an injunction. For our closing piece, the Bureau of Industry and Security, BIS, and the Directorate of Defense Trade Controls, DDTC, have proposed new rules expanding controls on U.S. persons support for foreign military and intelligence services. These measures aim to prevent adversaries from gaining critical military or intelligence advantages, reinforcing the need for strategic export licensing requirements. One of the key proposals is the introduction of a foreign security end user license requirement. This would apply to certain exports, re-exports, and in-country transfers of items under the Export Administration Regulations when they are destined for specific end users, particularly in countries subject to U.S. arms embargoes. The license would be mandatory if exporters are aware that an item is intended for entities with governmental authority to arrest, detain, monitor, search, or use force. This includes the comprehensive scope of governmental police and security services and extends to analytic and data centers, forensic labs, and similar entities. The BIS also proposes a new control on AI-powered facial recognition technology designed for mass surveillance and crowd scanning. This control aims to address human rights concerns by preventing the misuse of advanced surveillance technologies by repressive regimes. The technology would now fall under a new export control classification number and would require export licenses for destinations listed under Crime Control Column 1 in the BIS country chart. Moreover, the proposed rules expand existing restrictions on U.S. persons' activities related to foreign military intelligence services. This includes broadening the definition of military end user to capture mercenaries and non-state actors engaged in combat-like activities. The expansion also covers nearly all items subject to the EAR, increasing the control scope to a broader range of activities, including facilitating military contracts or providing technical support. Another significant component is the updated military support end users control. This new category would apply to individuals or entities whose actions support military end uses, requiring export licenses for such support activities in certain countries, particularly those in groups D, 5, and E. The changes are part of an effort to address growing complexities and ensure the robust oversight of U.S. technology and expertise spreading to foreign security entities. Additionally, the DDTC aims to refine its definition of defense services to include guidance and consulting on the disablement or degradation of defense articles, further reinforcing the regulatory perimeter around sensitive military capabilities. These revisions are accompanied by new USML entries designed explicitly to capture defense services related to intelligence and military assistance. BIS and DDTC have opened the floor to public comments on these proposed rules until September 27th. Trade practitioners should not only review these proposals, but also assess their compliance frameworks to ensure readiness for these stringent controls. The proposed changes highlight an intensified focus on keeping sensitive technologies in check, safeguarding national security, and promoting global human rights. Stay ahead by integrating these anticipated changes into your compliance programs, and consider submitting comments to BIS and DDTC for clarifications on enforcement and practical implementation. These updates are poised to reshape the regulatory landscape, making it crucial for trade professionals to remain vigilant and informed. Thanks for tuning in to International Trade Minute, Quick-Fire Trade News. We hope you found today's episode insightful and useful for your practice. Remember, our podcast is brought to you by Rydell Law Firm, your trusted partner in navigating international trade law. Don't miss our next episode. Subscribe now on Apple Podcasts and Spotify. Stay connected and continue the conversation with us on LinkedIn. Until next time, stay informed and stay ahead.